We'll give it a couple more minutes.
Okay.
Joe or Courtney, how are we looking participants?
We have 6 attendees in addition to our panelists.
Okay.
We are now recording so that we can get started. Are you ready?
All right, why don't we get started? And others can join us as we go along. I'm sure we will have others that will be joining us here today. I just want to say thank you first for everybody who is attending, particularly all those hardworking municipal officials that are out there. We know that this is a difficult time. It's surprising we're already into our 8th week. We're starting our 8th week since the governor's original order on March 6th. And I think it's going into our 6th week of since the stay-at-home order. And while it looks like many of us are here at the office, I'm certainly not at the office right now. I'm actually at the beach, and I'm looking forward to hitting the waves a little later. But in the meantime, while we're back at the office here, we thought, you know, right now this is a difficult time for all of us, particularly the municipal officials. There's a lot of different things that are happening, both that at the office for you guys, changes in the law, changes in procedure, governors issuing orders, and every day there's something new that's coming out. The most recent one that has come out is Act 15 of 2020. It was formerly House Bill 841, and it's a very long piece of legislation. And you have to get about 3/4 of the way through it until you start hitting the important pieces for municipal government. And we're here today to review with you those pieces of the new act that are going to impact the municipal government over the next couple of months. And we have put together a team here of our municipal attorneys who are prepared to go through those different sections of the act and to then answer any questions that you may have. And to do that, and before we go any further, I want to turn it over to Joan London, who is the chairman of the Municipal Law Department from Kozloff Stout. Joan?
Good morning. On behalf of the Municipal Law Section at Kozloff Stout, we are proud to help you stay up to date on the latest legislative developments on the evolving situation with the COVID-19 emergency. I echo Dan's thoughts, thanking you for all you do to keep our communities safe. You truly are essential personnel, now proving it more than ever. Today's presentation is on Act 15 of 2020, signed by Governor Wolf last Monday, which addresses some of the hardships created by COVID-19 and closures required by the stay-at-home orders. My colleagues, Dan Becker, who you just heard from, Alex Elliker, Courtney Berniker, Brian Boland, and Andy George, will be addressing the parts of Act 15 which apply to your local agencies for the duration of the emergency. The first section will be conducting public meetings by telecommunication device, such as Zoom, which we're using now, and WebEx, how to hold a meeting or hearing while following Sunshine Act requirements. Dan will be talking about tolling of MPC deadlines for development applications. The MPC has some very strict deadlines to protect the rights of property owners to have their plans reviewed, or approvals or hearings held in certain timeframes. And that has been told, and Dan will be talking about that. We'll be discussing the property tax payment extension. Alex Elliker will be discussing that. Stay-at-home order has closed businesses and created a lot of financial hardship to property owners. Act 15 allows taxing bodies flexibility. There's also going to be greater flexibility. Courtney Berniker will be talking about the education tax credit and its payment terms. Brian Boland will be discussing school district renegotiation service provider contracts. Schools in Pennsylvania have been closed, and this impacts the contracts for services such as food service, instructional services, and transportation. And then finally, Andy George will be talking about remote notarization and the plans and agreements that have to be notarized before recording at the county level. We'll talk about how that can be done in a contactless way. Let's get started. Courtney, if you go to the slide about conducting public meetings by telecommunication devices. Okay, since the March and April meeting cycles, most of you have used some form of telecommunications to hold your meetings so that you didn't have to have the risk of in-person meetings, but could take care of important business such as bill paying, infrastructure updates, renewing your emergency declaration, and updates on maintenance and repair items, and also previously advertised ordinance. You relied on the powers in the absence of anything else as authority of Section 7501D of the Pennsylvania Code, which temporarily suspends formal requirements in a declared emergency. But it didn't really give you guidance, and Act 15 gives a clear authorization to use telecommunication devices. You may now use, as a political subdivision, an authorized telecommunication device to conduct your meetings. And the first question is, Courtney, if you can change the slide. What is an authorized telecommunication device? And it is defined in the statute as any device which permits at minimum audio communications between individuals. So it's at very least a speakerphone where the individual outside can communicate with the board or council, and you can hear and interact with each other. It's the interaction requirement that most of us relied on under the Babbitt versus Pennsylvania Milk Marketing Board case that first allowed speakerphone participation in the 1990s, as long as that interaction requirement was met. But technology has obviously evolved since then, allowing web platforms like we're on now, and there are others like WebEx and GoToMeeting, which allow video and audio participation. And these present new opportunities for remote participation. And Act 15 gives us guidelines. First of all, there are notice requirements, and Courtney, you could change the slide to talk about notice. There are still notice requirements for meetings. And where does the notice have to be posted? It has to be posted on its website. Most municipalities have a website, or in an advertisement in a newspaper of general circulation, or both. And I also recommend posting at the municipal building as well. You have never had an action reversed for giving too much notice. So I'd say give as much notice as possible. Go to the next slide. What must the notice include? Under Act 15, the notice isn't that different from the newspaper and posted notice that you give, with one exception. It gives the date, time, and place of the meeting, but it also has to give, for remote telecommunication participation, the technology used. Is it going to be a speakerphone, Zoom, GoToMeeting, WebEx? And it has to give public participation information. What is the call-in number? What is the password? What is the meeting ID? Or how would you be able to access this meeting? There have been some security concerns with Zoom and Zoom bombing, and there are certain technologies with Zoom, such as the waiting room feature, that allow you to know who is participating and ask why. However, I don't believe that that can be used to keep someone out who is not being disruptive of the meeting, but it is good to be able to track who is there and what they are doing. As far as how much notice is given, the statute on regular meetings isn't clear. I believe the 3-day rule, like you would have for meetings under the Sunshine Act, is the safest guideline. And that's for meetings. But what about hearings and other proceedings, especially on land use applications, such as the hearings Dan will be talking about next? What notice is needed there? And go to the next slide. And that is a different notice, and it's notice in excess, in some cases, of what the municipality's planning code requires, because if an application or plan or submission or appeal is being considered that's unrelated to the COVID-19 emergency declaration, there has to be 5 days notice that's given on the website or the newspaper or both. And that is for the duration of the emergency. That is not limited to telecommunications device participation. And go to the next slide. Let's talk about public participation. Under the Sunshine Act, there is a right of reasonable public participation. Act 15 also provides for this and recognizes that not all have cell phone or internet access for remote participation. So to allow for reasonable public participation, the governing body has to allow, to the extent practical, and all of this, just like 7501D, is a do the best you can, good faith standard. It's untested. There may be actions in court later, but I think if you can show that you did the best you can to follow the notice rules, I predict that the courts will look at the good faith and attempted compliance. But the notice has to be by U.S. mail to the agency office, that opportunity, or by email to an account that is designated for public comments. But there has to be an opportunity not just for in-person participation, but also for email comment, and that should be ideally in the notice as well, that is on the web and in the newspaper. Go to the next slide. I want to talk about emergency meetings. The Sunshine Act allows for, as an exception to the usual notice requirements, meetings without public notice for the sole purpose of addressing the emergency, the immediate threat to life, safety, health, property. Act 15 also allows emergency meetings, but requires minutes to be kept and posted, as the Sunshine Act does, but it provides for a more specific time limit for the posting of those minutes. The minutes must be posted, or the draft minutes, which is what they really are, for an emergency meeting, within 20 days of the meeting, or otherwise prior to the next regularly scheduled meeting. And the minutes are subject to approval, and the actions are subject to ratification at a public meeting, as with any other action that is taken. Go to the next slide. Act 15 also has the feature of relaxing the quorum requirement, especially that found in the Borough Code, which requires a quorum to be physically present in the meeting room. Being that many of our meeting rooms are close quarters, because after all, we are among friends, which is important, but right now, not so much so. We want to allow safe physical distancing. This requirement is waived for the duration of the emergency, and the quorum may be established through presence by a telecommunication device. Again, the requirement is one of interaction. Before I hand this over to Dan to talk about tolling of MPC deadlines, we do have the chat feature. Submit any questions or comments that you have that you'd like to talk about, and we'll address them at the end of the presentations. Now I'll introduce Dan Becker, who will talk about the tolling of the MPC deadline for development applications.
Dan, I believe you're still muted.
Let's try again. Courtney, let's jump right into the first slide. So what you can see is the general proposition is that Act 15 of 2020 tolls the MPC guidelines for review and approval. And basically it's going to do that so that it starts, or actually it starts on May 6th. We're going to talk about this a little bit more in a moment, but starts on March 6th, and will go through the 30 days after the governor signed the order on April, just like that, it slipped my mind, but April, what was that date? April 20th, and so we'll go to May 20th. So let's go on to the next slide. Basically, what the Act specifically provides is that, notwithstanding any other laws that are out there, any provision that deals with approval of plans or any type of action that's an application for a plat or a plan or submission of an appeal, all of those different items are going to be stayed for, if you want to stay them temporarily. And there's 3 different requirements. So Courtney, if you want to go to the next slide, please. the first one is the tolling of the approval deadlines. So as of the effective date of the governor's order, again, which was March 6th, we're going to stay or toll any of the statutory limits for reviews, hearings, and decisions. And they're going to be stayed until 30 days after the date of that order, which again was on April 20th. If we go to the next slide, Courtney, you'll see those important deadlines or those dates, I believe. So again, the first date was the governor's order was signed on March 6th. The enactment of Act 15 was on April 20th. That means that the tolling period will end on May 20th. So that's a total of 75 days, which you can take advantage of. And it will depend upon whether the plans were already pending at the time of the governor's order on March 6th, or whether they came in subsequently, but that's how you'll do those calculations. So remember, if you have 75 days in which you can toll the review process or decision-making process, if the plans or the requests for those approvals were in before March 6th, if they come in subsequently, then you would have to calculate based upon the day that the plan or the action was required. Courtney, if you go to the next slide, please. The second requirement that's out there, interestingly, it's a little bit strange, but they're requiring, and it says shall in the act, that we shall provide each applicant with a written notice of the time extension that's authorized by Act 15. And we have to tell them in there that they have the right to request that the hearing or the proceeding or action be taken care of during that period of time if we want to do that. But then they go on right after that and they qualify it and they say, well, but if you fail to send out, or if they fail to get that notice, they fail to receive the notice under the section, it's not going to affect the tolling requirements for any, to complete those reviews or hearings or decisions. So what I'm suggesting and what we're suggesting at Kozloff Stout is that you do, if you have anything like that that's pending, and if you are going to take any action to toll the statute, and you haven't done it already by some other form of agreement, then what you want to do is you want to send out that notice. Courtney, go on to the next slide, please. The third requirement actually ties back into the second requirement, and that is the third requirement under the Act 15 is that you have to give the applicant the opportunity to request that they proceed with the proceeding or the hearing. Again, there's some qualifications on that, and it's at the sole discretion of the municipal body to decide whether or not they're going to grant that request or not. So if for instance, you have a zoning hearing scheduled during this period of time, or a plan review that's scheduled for a decision during this period of time, the applicant can ask for you to proceed in accordance with the existing timelines, and then you have to make the decision. The board or the local agency has to make the decision as to whether they're going to do that or not. So you probably hear us talk about, your solicitors talk about that typically requests for extensions are a shield, not a sword, which means that the applicant has to be requesting it. We can't force it. In this instance, it's actually up to the municipality to make that determination. If you decide that you're going to grant them the opportunity to proceed, there's some good news that comes out of that. It's consistent with what happens by law anyway, but they've now put it in directly into the legislation, which is if you grant it, then anybody who received actual notice is waiving any challenge to the timing and the participation and so forth. So it's clearly a statutory waiver from them making any challenges to the procedure. The other thing is, and Joan touched on this a few moments ago, if you grant the proceeding to go forward, you have to give at least 5 days notice, prior notice of the hearing moving forward. And you have to do that either by publishing it on your newspaper, publishing it on your website, or you can do both. And frankly, it probably makes sense to do both, but either way, you can accomplish and satisfy the requirements of Act 15. Courtney, if you go on to the next page, please. Okay, so the expiration of the tolling period. So here's what happens. I mentioned to you a few moments ago that you have a total of potentially 75 days. So it goes from the March 6th deadline until either the emergency declaration is terminated, which I doubt they'll terminate the emergency declaration. They may have people going back to work. They may change certain provisions, but I expect that we're going to be within that emergency declaration well past May 20th. If for some reason that's not correct, then the tolling period will terminate prior to the May 20th deadline. Otherwise, it'll be the May 20th deadline, which gives you that 75 days, which I mentioned a moment ago. Please go on to the next page, Courtney. If you remember the tacking provisions that occurred during the Permit Extension Act of 2013, there was some court cases that started out of Lancaster County. They went forward, and what they did was they allowed you then to take whatever time was told and tack it on to the back end of the requirements that are currently existing under the NPC for review process. Unfortunately, Act 15 doesn't specifically address the tacking provisions, but what it does do is it defines approval, or the approval process as defined in the Permit Extension Act of 2013. So that certainly clearly implies that tacking is going to be permitted in this particular instance as well. So what we believe is going to happen is that tacking piece that we just talked about will be the 75 days if it was something that was pending at the beginning of the March 6th order. Courtney, if you want to go on to the next page. And then just in summary, kind of the take-home points, the things that you need to keep in mind are the dates. And I've said them repeatedly. March 6th is the date for the original order. March 20th is the day that it's going to expire. Once it expires, important point, once it expires, it's business as usual again. And we're going to talk about that just in a second. The other thing to remember, the take-home point, is send out that written notice to all parties if you're going to be invoking the tolling period at all. For instance, because Act 15 was approved so late in the process, many of my municipalities have continued to operate as if those deadlines still apply. So they've been working it with the applicants, and in most instances, not every instance, but most instances, the applicants have been gracious and they have agreed to the extensions. If you have those extension agreements, it probably doesn't really matter. But to be safe, what we're telling you is you should be sending out that notice invoking that time period of the tolling period. The second part of that is, remember, you can tack on the additional time as may be necessary up to that 75 days, depending on the timing for the plan review or approval process. And then probably the most important thing to remember is this. The tolling period is going to end on May 20th. And we still may be in a position where we're going to be subject to social distancing. So the question then becomes, well, how do we proceed with social distancing when we're going to have some kind of plan review or zoning hearing, or, is there inspections that are necessary? What do we do in those instances? They're the things that we need to start thinking about now. Do you do it where you have the meetings at the office, the hearings at the office, or at the township or municipal borough buildings, or do you do it by Zoom? And there are things that you're going to have to look at for each individual municipality yourselves. Start talking to your solicitors, work out the details of how you'll try to run those type of meetings. But I think that's going to be the important next step of this, because after May 20th, it looks like we're going to be back to business as usual and have to figure out the best way to do that and still accommodate the social distancing. That's all I have for now. I thank you very much. I'd like to turn this over to, I believe it's Alex that's next.
Yep.
So Alex, I'll turn it over to you.
All right. So thank you everyone for attending this morning. This is an interesting way of communicating with all of our clients and friends here. So one of the initial questions that popped up as soon as the closures hit and everyone started working remotely was what were we going to do about property tax, because the government immediately put those extensions on federal income tax, which then led to state income tax, the returns deadlines being extended out to, I believe, in July or so. So a lot of our clients came to us and said, well, what do we do about property tax? It's a pretty big bill for a lot of our homeowners to receive. And if they're planning accordingly, all of a sudden they get hit with income loss. What do we do? So if you could go to the next slide, Courtney. So on average, you usually see around 80% collected in that discount period, where you get a couple points knocked off just because you guys are paying early prior to hitting that endpoint, and the municipalities are able to receive, as the taxing authority, those revenues from property tax earlier. You get a little bit of a discount period. So the majority may have already been paid. Maybe there's a few of those percentages that kind of said, well, there's all these other relief coming in for income tax, for mortgages, for different utility bills, things. Maybe I could get that. And some of them may have kind of weighted towards the flat period on this. But usually around that 10% or so are collected during the flat period, which is essentially you're paying the property tax that's due, but there's no discount given, but there's also no penalty given. So majority come in at the discount, but you get still a substantial portion that just pay the amount due during that May to June timeframe. And then you'll get kind of under 10%, but still a small, strong percentage of people that pay afterwards during the penalty period, where you can charge up to, I believe it's 10% interest on the tax that was due, that tax liability. So looking at this, I think, your county and your state officials noticed, all right, there's going to be a lot of property owners that will lose income, will lose employment, that may not be able to make this payment. So how can we help them, just like we've extended the tax return periods and things like that? So to do that, as part of the act that was just approved, Courtney, you could go to the next slide. For only 2020 property taxes. So this doesn't go to future years or anything. This is just for this year due to this pandemic and all the different emergencies and issues popping up. The Senate Bill 841 allows municipalities to take the following actions. You can extend your discount rate to no later than August 31st, 2020. So say that there was that little discount of points that you get if you pay early. You can technically extend that from, say, the end of April all the way to the end of August of 2020. You can additionally waive any late fees or penalties if you pay it in full by December 31st. So essentially that's extending that same flat rate until the end of the year versus just, I believe it was the end of July. So, or the end of June. So to enact those changes, the municipality needs to pass an actual resolution within 30 days, as they put it in the act, within 30 days of the effective date of the act. So that kind of starts the clock rolling, that if municipalities want to do any of these things, they should act kind of immediately at their next meeting to get this resolution passed. And you're supposed to then deliver that resolution to your tax collector. So the important thing here is, your tax collector is the one that's documenting all this to see who's getting a discount, who's paying flat, who owes a penalty based on all of this. So if your tax collector doesn't know that you guys have extended any of these deadlines, they're going to be still using the old deadline. So very important that once a decision's made on this and a resolution's been passed, and even prior to that, the municipal officials are working with their tax collector to make sure everybody's on the same page going forward. If you could go to the next slide, Gordon. So what's gone on in other areas here, the county, the county commissioners and the treasurer have made their own decision. They're not going to extend the discount period. What they're instead doing is extending the flat period towards the end of September. There's a bunch of different reasons that they chose to go that route, but they felt that was the best way to help out the residents of Berks County that owe property taxes given this issue, but also kind of keep certain deadlines in place. They've encouraged municipalities, and I believe a lot of you, either as the municipal manager or different officials, probably received a cover letter from the county commissioners and the treasurer to that effect, saying we are extending the flat period only to September 30th. We are not extending the discount period, and we'd like you to do the same. So everyone's kind of in conformity with those dates. So there's no confusion between different municipalities. You can choose to go along with that and kind of go with the commissioner's kind of recommendations on that, or you could make your own decision to extend the discount period longer than what it already is, and possibly extend that flat rate period to longer than September 30th. That's, again, an individual decision for each of our municipalities to go through. But the important thing is then making sure that that decision is approved through a resolution and communicated with your tax collector. So there's a sample resolution that was attached to the county commissioner's letter. You could use that to use that extension of the flat rate period, or you could, work those dates to change it to something else that makes sense. So again, to kind of wrap this up, each municipality should decide whether or not you want to conform to the county's actions or extend those dates to from the August 31st with a discount, or to the end of the year with the flat rate, and make sure you pass that resolution. So thank you guys for attending. I'm going to pass it over to Courtney for the educational tax credit.
Thanks, Alex. So the educational tax credit is a tax credit that's available to operating businesses in Pennsylvania. And it's unlike a lot of other tax credits where you reflect on your tax returns and you get the credit for it, it requires an application to the Department of Community and Economic Department of Community and Economic Development, who, if you have been looking at everything else that the governor's office has been doing with the life-sustaining business order and the many other orders since the pandemic has started, this is the same department that's handling the waivers and everything else. So in light of that and the economic effects of the pandemic, this tax credit, which requires an application, they have adjusted the timeline for applications so that our operating businesses and our communities are still entitled to the credit, and they are still encouraged to make contributions to scholarship organizations, educational improvement organizations, and pre-kindergarten scholarship organizations. And all of those that are eligible organizations are listed on the DCED website. But this credit typically requires that there be an application and then the payment be made, the contribution be made within 60 days. And that's one of the two changes that have occurred for 2020 and only 2020. For reference, the tax credit is equal to 75% of the contribution with a maximum amount, or it can be increased to 90% of the contribution if that business has made a written commitment to provide the same amount for 2 consecutive tax years. And so because this pandemic has only happened in 2020 and is affecting businesses in 2020, many of them have already made a commitment, and there's some that are already in the process of trying to get the educational tax credit 90% threshold by making contribution in both years. And so Act 15 of 2020 tries to help those businesses who had the good intentions of giving to these educational organizations. So the first change was to extend those deadlines from 60 days from the approval of the application, which we should be telling all of the businesses in our community that turnaround for that application may be delayed because that department is doing some extra work this year while they are dealing with the life-sustaining business orders and a lot of the waivers and other questions going on. It's now extended to the end of that firm's applicable tax year. So for some businesses, their tax year is December 31st, some are different, so they should be consulting with their accountants. But that also changes when contributions may be made to these organizations. The proof of the contribution must be submitted within 30 days of the contribution. So even if it's made in December, and for them to be eligible for the credit and to receive the benefits of the credit, they still have to provide proof of the contribution. And then those that are in that 2-year commitment time period are still going to get the intended tax benefit behind this 2-year program that's been in existence for a long time, even though there is a very sharp economic downturn during 2020. So any firm that is currently in their year 2 of their 2-year commitment will still receive a tax credit equal to 90% of the amount they contribute this year. And they won't have their first year tax credit affected. So typically the amount has to be equal from one year to the next for them to be eligible for the tax credit for both years. this will allow for them to adjust their contribution based off of the economic downturn this year. As we know, there's a lot of businesses that aren't operating right now. And while this will, this helps them through that, but also allows them to and encourages them to still make contributions to those educational organizations. If you have any questions about that, I remind you all that we do have the question and answer feature that we'll be using it when we're done. But at this time, as we're talking about school districts, we're going to move over to Brian Joseph Boland.
Thank you, Courtney. Okay, so what Act 15 has done is address a problem regarding the renegotiation of school service contracts, considering the fact that these services are no longer provided or provided to a lesser extent because of the emergency. Could you go to the next slide? This was first introduced in Act 13, addressing the school transportation contracts, but was then later expanded to, all service contracts with Act 15. So I want to start with Act 13 and go on. Next slide. Okay, so what Act 13 has said regarding transportation service contracts is that each school entity may renegotiate a contract for school bus transportation services to ensure their personnel and fixed costs, including administrative and equipment, are maintained during the closure period. The second provision talks about, in order to continue being paid, they have to submit weekly documentation that their complement levels remain the same or above when the closure period began. So that is, in a transportation service contract, maybe the drivers and the fleet are maintained in the same way because the payments are for the sake of keeping the contractor afloat during this period so that the continuation can begin when the closure period is over. This third section is what has drawn a little bit of confusion and a lot of interest, and that is about the reimbursements. So what the third part says is that, notwithstanding any of the other act, if the school entity continues to pay the transportation contracts, then they will be reimbursed at the regular rate that they would have received if the pandemic had not occurred. And this has become a problem because schools have become a little bit concerned about the way in which changing their payments to the contractors during this period might impact their reimbursements for the following year. And the Pennsylvania School Bus Association has put out this opinion that is drawn, I believe, has created a little bit of confusion, because the way they have worded it is that when the statute says, if you continue to pay, you will be reimbursed, their opinion has then been that your ability to be reimbursed in the future will be imperiled if you do not pay to a certain extent. And so this has been then used to put a little nerves in the school district to say, okay, well, we don't want to cut costs too much because we don't want to have negative impacts down the line in terms of reimbursements in the future. And so two common questions have come up that are on the next slide that PDE has addressed. So how will subsidy payments for contracted pupil transportation services work under the context of Act 13? So PDE says essentially that it's just going to continue working according to the comparison of actual costs, and it'll just scale. So if a school district were to continue to pay according to the regular contract, they will receive the regular rate with the regular costs. And if the contracts are renegotiated, then it will be the regular rate, but scaled down to the actual costs under the renegotiation. And then furthermore, as I was discussing before, the question comes that, well, how will this impact our future reimbursements? And PDE is a little bit vague, but at the same time kind of straightforward in that the transportation subsidy in the future will be impacted by the costs incurred under the renegotiated contract. So again, it's the same rate, it's just scaled down according to the costs as they have changed under the renegotiated contract. And there's been this idea, because I think of the different reading that has been put out, that there will be some kind of penalty or punishment or unknown negative impact that will result from renegotiating and lowering costs, but I don't think that's the case. I think it is just going to be the case that to the extent that payments are lowered under the renegotiated contract, and to the extent that reimbursements in the future are dependent or relative to actual costs in the prior year, will be scaled down with the actual costs that were arrived at from the renegotiated contract. And I think from that perspective, it's just a math problem to figure out. You just want to look to the contractor and say, okay, what are these fixed costs? What are the personnel administrative costs that have to be covered? Present those costs and say, okay, here's what we need to pay you in order to cover those costs under the act. And you reduce the amount paid, and then the rate is the same, but the actual costs are lowered and the reimbursements will be correspondingly lowered. But it doesn't need to be a mystery, and it doesn't need to be a negotiation in the abstract sense. All of these numbers are knowable and the problem is solvable. So it doesn't need to be in some lump sum payment, as some people have been tempted to do, of, okay, well, we could be paying according to the lower cost, but why don't we just cut it by, let's say, only 25%? We'll give you a lump number because we fear how this will affect reimbursements in the future. But I think it just should be treated as an equation and a knowable and solvable problem. Now, this was then expanded upon with Act 15 that broadened the problem, because the question was then, okay, well, now we understand how we should go about transportation contracts, but what about other contracts? What about other contractors that are no longer providing services or providing a reduced amount of services? Can we keep paying them? Is there an address that we can do in the way that we've done transportation contracts? We know that the CARES Act recommends or says that school entities should continue paying contractors, but is there any state guidance on this like in Act 13? So Act 15 just says essentially the exact same language, but including all contract service providers. So renegotiating these contracts to ensure personnel and fixed costs, administrative costs are covered. So this might be something like groundskeepers, or if you can track cafeteria services or substitutes or a school psychologist and so on. You may still want, for example, a groundskeeping services to provide some services. You may want to cut in half the amount of times they cut in the grass now that people are no longer on the fields or on the grass and so on and so forth. So you want to renegotiate these contracts to account for the reduced number of services, but still covering those costs so that the contractor can maintain its business and continue business as intended when the closure period ends. Now, I will send it over to Andy George to talk about remote notarization.
Well, thank you, Brian, and thank you to all the attendees this morning. So, as Brian said, I'm here to talk about the very exciting topic of remote notarization and the recent changes that Pennsylvania has undertaken. We need a little bit of history first, so we can go to the first slide. Way back on April 2nd, 2020, there was an order that came out, and this order came out from the Pennsylvania Department of State. And what that did was temporarily suspend any in-person requirements for notarization. So when a document's normally notarized, of course, the notary and the person signing that document are in the same location. But these changes were only made for certain documents. So they allowed remote notarization of powers of attorney, self-proving wills, and temporary guardianship. However, other documents were also included in the mix, which are healthcare powers of attorney and living wills. So the first set and the second bullet there, those, all of those require notarization. The second set of documents, powers of attorney for healthcare matters and living wills, notarization was never required on those documents anyway. However, it's best practice to do that. The order from April 2nd also said you need quote unquote tamper evident technology, but that wasn't defined and nobody really knew what they were talking about. So, you know, that was left, a question left unanswered. And then also, it was kind of crazy that the order itself did not include codicils, which are amendments to wills, and trust agreements were not included either. So if we go to the next slide, we see that Act 15 came into place, and it really served to clear up the questions that the order of April 2nd left unanswered. So the new rules state that a notary must complete an online registration form, and that's found on the Pennsylvania Department of State website, to become either or both a certified electronic or a certified remote notary. And all this information is on the Department of State website. There's a ton of valuable information. There's frequently asked questions. The application itself is free. E-notaries are different than remote notaries. So electronic notaries deal with electronic signatures. So that requires that the notary and the person signing the document need to be in the same location, but both can sign and notarize via electronic means. And of course, the remote notary occurs if the notary and the individual signing are in different locations. So also, the new rules say that the notary must notify the Department of State of the type of communication technology provider to be used. And we'll talk about that in a minute. Additionally, the remote documents need to include a statement like the one that's listed on the slide. This act of notarization involved the use of communication technology. There's no requirement that it refers to Act 15 of 2020, but that might not be a bad idea to put that on as well. So on the next slide, it talks about some additional rules that Act 15 came out with, and the notary can rely on certain information, same as today, 2 forms of governmental ID, or the notary can have personal knowledge of the identity of the person signing, or the notary can take an oath or affirmation of a credible witness that, yes, this is the person who is signing. Now, I mentioned briefly Commonwealth approved communication, and I have 2 listed, SafeDocs and DocVerify, and I think those are the first 2 on the list on the Department of State website. There's about 10 companies that have platforms that are recognized by the Commonwealth. Unfortunately, FaceTime, interestingly enough, is not on there, and neither is Zoom. So the way I understand that these programs work, you have to sign up for them. You have to pay generally a monthly fee. And I haven't done any research on what those fees are, other than DocVerify looks to be in the neighborhood of like $40 a month. Also, the notary needs to keep an audio-visual recording that will be retained for at least 10 years. And that recording has to be comprised of the entire interaction between the notary and the person signing the document. So we can go to the next slide, please, Courtney. Some additional rules. The notary has to be physically located in Pennsylvania. The person signing, though, could be located anywhere in the United States or in the United States territory. So, you know, this can really be helpful in situations where people are traveling for business. Those people that might be working out of state, potential military members that are stationed away from home. Additionally, helpful if individuals are homebound for reasons of, you know, healthcare or nursing homes possibly. Additionally, they can be used remotely to execute municipal related documents or real estate documents. You could potentially have a closing remotely. Online vehicle sales, I believe, is another area that would be benefited by this process. So additionally, the certificate of the notary has to list the county in Pennsylvania where the notary is located. So it doesn't matter where the person is signing. However, the county where the notary is located needs to be indicated. there is not allowed electronic signatures of estate planning documents. So some had thought maybe this would be part of the new legislation, but it's not. Additionally, with a general durable power of attorney, I call them financial powers of attorney, you still need in-person witnesses. So there's still no getting around that requirement. And I think that this law change was eventually going to happen. Just the pandemic kind of sped things up. All these changes that I've been discussing expire, and the expiration date is 60 days from the end of the Commonwealth of Pennsylvania Disaster Emergency Declaration. However, from what I understand, there's legislation that is underway now that will extend this and these rules for remote notarization and potentially make it permanent. So that's all I have. And at this time, I can turn things over to Joan for questions.
If you can unmute me. Yes, we received 2 questions. The first one I'll take because it deals with remote meetings and minutes. And the question that was asked was, is there any change in the time that the minutes of the regular meeting must be posted, or does Act 15 and that section of Act 15 just apply to emergency meetings? That section of the statute only applies to emergency meetings. It doesn't change the timing on the minutes of regular meetings. It's just a requirement, reiterating the requirement that minutes be kept of emergency meetings and stating when they have to be posted. And there was a second part to the question as well, and that is, how do minutes get approved if there's no meeting in those 20 days, or do you just post subject to ratification? I think that what the statute means is that these are draft minutes that are posted on the website and posted and available for review within 20 days or prior to the next regular meeting at which they would be ratified. I think the better term for them would be draft minutes. They are not yet approved minutes. But what it's doing is it's as you know, under the Right to Know Act, you don't have to produce the draft minutes in response to a request. Generally, they're included right outside the meeting room or in the meeting packet. Here, they're attaching a requirement to have some transparency with emergency meeting minutes, and it makes sense because it's a meeting that was conducted without notice. The second question
Joan, before you go on, I think part of the impetus, just so for clarification purposes, when the legislators started taking a look at this, there was a House bill that was proposed, and that House bill had a lot of additional requirements for posting of all minute meetings.
Yep.
But when the Senate bill came out, they changed it, and now it only applies to those emergency minutes. Our emergency meetings are the COVID meetings, which don't even have to be advertised. And that's the reason why you have to post the minutes within that 20-day period.
Right.
So people understand what was going on during that period of time.
Does anybody else have anything to add on that before we move on to the next question? Okay, next question is for Andy, and it's about remote notarization. The question is, does remote notarization apply to deeds, or must deeds be notarized in person?
Well, Act 15, and I don't believe the order of April 2nd, identified deeds as specific documents. So it only identifies, Act 15 only identifies documents that would have the requirement of witnesses, and deeds, as far as I know, don't require a witness. So yes, it would apply to deeds, and it just matters that the person notarizing the document would be a certified remote notary in Pennsylvania and is located in Pennsylvania. I have heard that before this act came into place, I heard that Virginia notaries were being used. They were kind of at the forefront of this new legislation and had the remote notarization in process some time ago. So until some in Pennsylvania get up and running, I guess you can in your states. There's nothing that prohibits that. However, yes, a deed would be one of the documents that could be remotely notarized.
And let me add on to that a little bit, if I may. And I see we have Brian F. Boland here, and we can talk a little bit about what we've done at the firm to help out with the notarization issues. Brian, if you want to, I'm kind of putting you on the spot, I know that, but to get into and explain kind of the process that we put together to notarize documents for people that need them done right away.
Well, what we've done we've done some parking lot executions, particularly for people who needed wills immediately, some first responders, some doctors, some nurses, things like that, who were concerned and wanted to get a will done, powers of attorney done, healthcare powers of attorney done. And we were able to do them in the parking lot. The documents obviously were drafted, sent to them to be reviewed by email. Then there was a telephone conference with them to thoroughly review the document, and then set up a time after we had an exchange of a couple of telephone calls to make sure they were right. We then set up a meeting in the parking lot where the documents were given to them on a clipboard. They brought their own pens. They signed them. We had a notary and the appropriate witnesses standing 10 feet away from the car, watched them sign. All the documents were tabbed so they knew where to sign, what to exchange. We took the back documents back from them, witnessed them, and then placed them in the vault or mailed them out. Appropriate. So it can be done.
Yep, thank you, Brian.
Mm-hmm.
John, I see there's another question.
Yes, there is another question, and actually it's for you because it's about the tolling of deadlines under the MPC. The question is, does the tolling of deadlines apply to all applications, any applications filed under provisions of the MPC, including variants and special exceptions? What about building permit applications under the building code?
I believe it applies. That 75-day period, I believe, applies to all those, the zoning variances, plan review, building permit applications, all of those different types of requirements for approvals. I think that's really important to understand is it's that 30-day period that's really left, actually less than that right now, is not a long period of time. So two things. First one is if you're going to invoke the tolling and you don't have some other agreement. So remember, if you are already operating under the same the regulations that currently exist, which most municipalities were, and you've talked to the applicants and they've agreed to an extension and you have that worked out like you normally would for extensions, then I don't think some of this really matters. But if they don't, and or they're refusing to give you an extension, or you can't get them, or whatever the case may be, then I think you want to send out that written notice that we talked about earlier and let them know, what their options are. But more important than all of that, 30 days from now, or again, less than 30 days from now, we're going to be in a position where we have to proceed. So you need to start thinking about the requirements of how you proceed, whether it's a plan review, whether it's a Zoom zoning hearing. I actually am working on setting one of those up right now for a client, just so you can have that same type of interaction. It's going to be new. I mean, it's going to be a little different, but I think it's something that everybody needs to start planning for now. I was recently on a call with PSATs and some folks from Penn State, where the question was asked to the PSATs legislative folks, do you think that 30 days will be extended? Now, these are the guys who have been talking to the legislators, and they said, no, they don't think they're going to extend it beyond that. There was discussion about that. It was pretty emphatic, no, it doesn't look like that's going to get extended. So be prepared that you're going to end up with that tolling period ending on May 20th, and that we have to proceed with those hearings. Good question. Thank you.
I don't see any more questions.
Joan, I just want to, I think there was one comment, I think, from Troy Bingaman, that just to keep in mind that the county billing system is not set up to have varying dates between county and the municipal side. So I think part of the reason why they sent out the letter for the September 30th flat rate extension was to make sure that their billing system kind of stays uniform with everybody else. That's not to say that municipalities themselves are required to do the September 30th date, whether that's the flat rate or discount period, no extension. But I think doing that makes the process a lot easier for the county side, just streamlining collections and their computer system. So just something to keep in mind.
And I agree, and that's what I've seen too, that there's a preference. I see that another question has come in.
While you're looking at that question, let me follow up on Alex's a little bit too. Please know that if you need any help with your resolution, I think the county sent out a very simple draft resolution. It does need a little bit of cleanup work on it to make sure that a couple things, that it's applicable to your municipality, or there's also some language in there that I thought really should be tweaked up a little bit to make it applicable and more clear. But let us know. We'll be happy to help you out with that as well.
Okay. Andy, I have another question for you regarding remote notarization. And the question is, as a notary, I was under the impression we could swear remotely. Does this mean we should be registering with the notary office for remote swearing also?
I don't think that's the case. I think that would be covered under an exception. I don't think that anything needs to happen with court reporters. And I know that the question came from Audrey. There is guidance on this on the Department of State website, but as far as I know, court reporters would not need to do anything. So that is already okay.
So actually, to follow up on that, Andy, so you're talking about if we're doing, for instance, a remote hearing?
That is correct.
Okay, yeah, I agree. I mean, those remote hearings, I suspect, will be, recorded just like any other hearing, zoning hearing or conditional use hearing. So the stenographer would do it remotely. They'll, raise their hand or attest or affirm, and that would be part of the record. Good. Anything else, Joan?
I don't see any other questions. Does anybody have any other questions that they, or does the panel have any comments?
I want to do, I think we're approaching actually a little bit over. We want to try to keep this to an hour. I think we're, just a couple minutes over the hour. So since we don't hear any more questions or comments coming in at the moment, just a couple of final comments. I want to say thank you for attending. Really appreciate the folks and the questions that have come in. This will be, or is being recorded and will be posted on our website within the next couple of hours, probably. So if you want to take a look at it again and see all of our smiling faces, please feel free to do so. And if you have any questions or comments that you would like to bring to our attention, we're working remotely. As you can see, we're fully functioning right now. If you have emergencies of any type, we're here for you. If you need the notarization, we can still do it, even physically to the extent we need to do that. So if you have any questions, any comments, please feel free to give us a call. We'd be glad to help you out. Thank you very much for attending. Is there anything else, Joan, before we adjourn?
No, nothing else. Thank you for all of you for taking the time to attend, and stay safe. And we look forward to seeing you in person very soon.
Exactly. Thank you.
Thank you.
Thank you.